And the final case that's set for argument this morning is Aster Elements, correct title of this, Ohio Fabricators versus Aster Elements, case numbers 28911 and 28934. Are we going to have to divide up some time on arguing?
Yes, we're going to, two appellees are going to split 15 minutes even.
Okay, very good. Each side will have 15 minutes. The appellees can split theirs amongst them. And of course, the appellant may reserve up to 5 minutes for rebuttal. Just let me know how much you wish to reserve, and I'll keep you apprised of the time. The arguments that are heard today are going to be recorded and posted on the court's YouTube channel, so please keep your voice up and remain at the podium. And we've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. May it please the court, my name is Mike Stabnicki. I represent the plaintiff, appellant, Ohio Fabricators, or as I call them, Ohio Fab. I'd like to reserve 2 minutes for rebuttal, and if somebody can give me a kind of a high sign when I get to 3 minutes in this 13 minutes, I'd appreciate it. There's a point in time in every case or in every decision where people have to make the choice between what's right and what's easy. And in this case, the defendants improperly, by massaging language in a contract, gave the trial court judge an easy out. They said there's a pay if paid clause. And the judge applied that, but it doesn't apply at all. Just because something is easy doesn't make it right. We're here in the Court of Appeals to get the decision right. And thankfully we do have the appellate procedure to do so. Real quickly on the background, Ohio Fabricators is an HVAC and metal panel installer. And just so you can get a framework for it, on your wall here in the courtroom, you've got drywall. Behind the drywall, there's studs. On the exterior building, they call it the skin or the framing of a building. You would have metal girders, then a substrate, and then a decorative panel. I call it the Chipotle look, that metal kind of finished look. Ohio Fabricators was hired on the Cincinnati Children's Hospital job to simply install panels. And that's significant, and we'll get to that. They didn't design the building, they didn't design the ACM panel system, they didn't build the panels, they didn't provide the steel, they didn't do the girders, they didn't do the substrate, they just hung. Ohio Fab on this job is still owed $939,800.23. It essentially has worked on that job on a finished hospital for free for nearly a year and a half. The problems on this project were caused by defendant Aster. So here's the way that the contract broke down. Owner of the project is a Cincinnati Children's Hospital. Their construction manager is Messer Construction. Messer hires Pioneer. Pioneer hires Aster, one of the defendants. Aster hires, among other subs, Ohio Fab. Aster has a bond, which is defendant's travelers. So it's 5 levels approximately removed. Again, this job with Aster was a debacle, and Ohio Fab is being scapegoated, in my opinion, on it by the defendants. The wrong gauge steel was used on a children's hospital. They used weaker steel. They didn't use 16 gauge steel, they used 18 gauge steel. There were no approved engineered architectural drawings for the metal panels that would hang over children's heads. They were not stamped. They violate Ohio law, and the law which requires a stamped, approved engineer or architectural stamp. All of these were done by and through defendant Aster. The substrate, which runs through defendant Aster, was an unmitigated disaster. It was out of the line. The building is not square. I hate to use this terminology, but the substrate was referred to, and it's in the brief, in writing, and it's in the evidence, as terrible, out of whack, and pardon my French, quote unquote, effed up. Okay? In one area, the substrate was found taped to a children's hospital. Not anchored, not nailed, taped. Finally, to add insult to injury, defendant Aster was stealing or diverting the money that was owed to Ohio Fab. It's all in writing, it's all in the evidence. Ohio Fab learned of these problems, threatened to walk off the job, and was lured back onto a joint check agreement. The joint check agreement was signed by both defendants. We'll pay you all with joint checks, including the final payment. Still, Ohio Fab didn't get paid. It's owed nearly $1 million. It filed suit. As we get into the trial court, we file summary judgments, and the defendants find an inapplicable pay if paid clause buried in the general conditions which references payments by the owner. The trial court hangs its hat on that decision, and that's error. So here's why that's error. In the general, well, first let's deal with general contract law. Obviously, the court knows this all too well. Contracts are construed against the drafter. Defendant Aster drafted all these documents. I don't think there's any dispute on that. Ohio Fab did not draft them. If there is a pay if paid clause, the law, the courts strictly construe it against being a pay if paid clause. They're harsh. Courts don't like them. They're disfavored. So from a contractual law standpoint, it's construed against the defendants in both counts. But if you really look at the terms in the clause here, what the clause in the general condition said was, if the owner pays defendant Aster, defendant Aster had no contract with the owner. Defendant Aster had a contract with Pioneer. Pioneer had a contract with Messer, and Messer had a contract with the owner. The trial court changed the words in the contract to say, well, owner means Pioneer. Wrong. The notice of commencement on the job defines the owner as the hospital. The prime contract between Messer and the hospital defines the owner as the hospital. The deed for the property shows the hospital as the owner. The contract between Aster and Pioneer shows the owner as the hospital. Our contract shows Pioneer as the general. To add further depth to that, if you look at the terms of the general conditions, it doesn't make sense if Pioneer is the owner. Section 8.2.2 says, title shall be transferred to the owner of all the work. Are we claiming that title was transferred to Pioneer, a sub? Section 8.3.1 says, all liens must be bonded off, the owner's property. Are we claiming that we're meaning Pioneer's property? Section 2.1.5 of the general condition says, all warranties shall be transferred to the owner. Are we saying that the elevator warranty has been transferred to Pioneer, who hasn't been on the job for 2 years?
How about the president of the company's deposition testimony that
Sure.
he understood this to be a pay if paid contract?
Right. And I try to do a good job of this in the brief, but you can never get the full flavor, so sometimes you have to read the whole deposition. It's all taken out of context, and it's based upon the language of the contract. My client in his affidavit said he doesn't truly know what a pay if paid clause is. He looks at everything as a pay when paid. Pay when paid is a timing issue on payment. Pay if paid is that absolute bar. That's the way he interprets it. It's in his affidavit. But if you look at the deposition testimony and you really look at the questions asked, and I tried to point this out in my brief, they would ask, well, look at this general condition. Doesn't that look like a pay if paid clause? Not is it. What does it mean? Does it apply to you? That's the quote. The question was, doesn't it look like a pay if paid clause? He goes, that's what it looks like. But just because it looks like a pay if paid clause doesn't mean it applies. Sure, that looks like a pay if paid clause if it applied. If Aster had a contract with the owner, that's a pay if paid clause. Aster doesn't have a contract with Pioneer, doesn't have a contract with the owner, and the trial court literally said, well, it doesn't matter if it's the owner or if it's Pioneer, it all means the same thing. Wrong. The main contract, not the general conditions, the main contract says payment net 10 days. If they wanted a pay if paid clause in the contract to be unambiguous and not construed against them, why don't you put it in page 1 where the payment provision is? Say, you only get paid if we get paid by whomever, anybody. It doesn't say that. It's really easy to do. And that's because pay if paid clauses are so harshly considered. Pay if paid clauses are really dealt with when there's a bankruptcy, when there's a fairness issue. So if the hospital went bankrupt and nobody got paid, okay, then I guess everybody's going to lose. But that's not what happened. The hospital's open and operating. I drove by it last month with my daughter on the way to visit University of Cincinnati. Pioneer didn't go bankrupt. Messer didn't go bankrupt. This is kind of a shell game to avoid payment to Ohio Fab. Turning quickly to the joint check agreement. Let's assume that there was a valid pay if paid clause, which I vehemently dispute, but let's assume it applied. After all these problems on the job, Ohio Fab threatened to walk off, and defendants, Travelers and Aster signed a joint check agreement. If there's a joint check agreement that requires all these payments to come through, there's no condition precedent, because everything is getting paid. There's no payment here that has to come before the second payment. It changed the payment terms. A joint check agreement and the concept of payments kind of rolling or waterfalling down from generals or owners are inconsistent, because all the payment comes in at once. Ignoring pay if paid clause and ignoring the joint check agreement, defendants' arguments are also barred under what's called the prevention doctrine. And this court knows, I think it was its Integra decision, and there's decisions by the Ohio Supreme Court that says the prevention doctrine goes like this. If the defendant prevents or hinders the condition precedent, then they cannot use it as a defense. It's waived. If your bad acts prevent the thing from happening, well, then you can't use the condition precedent, because but for your conduct, it would have occurred. If defendant Aster hadn't had the substate just put up wrong, had no approved plans, maybe they'd have gotten paid in full. I don't know. But that action, that hindrance, their breaches, their negligence, prevent them from leaning on something else. Is it fair? Is it the law to say, okay, Aster breached everything, no plans, no substrate, the steel's wrong, money's getting stolen off the job, but hey, there's a condition precedent so you don't get paid. No. Their bad acts, their negligence, their breaches, their non-performance can't be used as a shield to the innocent worker. Turning kind of to a more basic point in this is the issues of fact. I mean, this is the most simplistic way for me to kind of deal with this case, besides that definition of owner that doesn't make any sense to me. There were a mountain of disputed issues and material facts. Let's go to the most important one. So we're talking about payment. In the affidavit attached to the motion for summary judgment, defendant Aster said, "We have not been paid." In the deposition of defendant Aster, they said, "We have been paid in full, except for retainage." And retainage never applies to a pay if paid clause. That's Ohio law. So isn't that an inherent conflicting statement? The Ohio Supreme Court in Byrd versus Smith said you cannot create a contradictory statement in an affidavit. Which Sorry?
You're at the three-minute mark.
Okay, then
You wanted to know.
okay, I'll go quickly then. So that is an issue of fact, inherently contradictory. Defendant Aster, it was proven in writing, was also absconding with money that was owed to Ohio Fab. Pioneer caught them doing this. That was one of the reasons for the joint check agreement. So what's the accounting? How much were they paid versus how much they diverted? There are 4 different payment provisions. Are we applying the main contract, the general conditions, the joint check agreement, or the bond? Issue of fact. Finally, most fundamentally, the contract itself creates an issue of fact. And that sounds weird, but bear with me for a second. Trial court said, well, this contract language is ambiguous, so we're going to substitute the word for pioneer for owner. If the contract is ambiguous, it is an issue of fact, the Ohio Supreme Court held, which requires factual inquiry. That's a trial, not summary judgment.
You're at 2 minutes now.
Okay. Real quickly, I'll deal with the bond, and I'll reserve 90 seconds, whatever I've got left. Bonds are strictly construed in favor of a beneficiary. They're there to benefit the sub. They're not there to benefit the owner. I mean, not the owner. They're not there to benefit Aster. They're not there to benefit the insurance company. To say that a bond is excused from payment because somebody else breached, or because that the owner wasn't paying, defeats the purpose of the bond. The bond protects the subs. And I'll reserve my remaining minutes. Thank you, Your Honors. We ask for reversal.
1 minute, 31 seconds.
Got it. Thank you, sir.
Counsel, do you have an idea how much time you're going to use as opposed to?
In speaking with Mr. Torrance, we agreed that I would split my time. I will try to stay to that 7.5 minute
Okay, very good.
point. I may finish early.
And I'll let you know if you get close to 7.5.
Thank you, Your Honor. May it please the court, I'm Timothy Fitzgerald. I'm here on behalf of the appellee, Aster Elements. We ask that the court affirm the trial court's summary judgment. Mr. Stabnicki cast this case in with a theory that it's an easy versus right issue that the court has to decide. I would submit that this is a case in which the question is taking responsibility for your own failings or trying to shift the blame to somebody else who didn't have anything to do with your own failings. And that's what we have here. We've got Ohio Fabricators, who is fairly well documented throughout the record here, failed to install the ACM panels correctly. The initial problems that triggered why it was found out that the panels were not secured appropriately was that 2 panels fell off of the building. I believe one was in August of 2015, the other was in early 2016. And it was discovered that those panels were not appropriately attached to the building. Subsequent investigation found out that that problem was pervasive throughout all of the...
But was that due to this improper substrate or?
The substrate had nothing to do with Aster Elements. Aster Elements didn't do any work on this project other than supply the ACM panels.
But neither did Ohio Fabricators.
That may very well be true, but that's why I'm saying that he can't shift responsibility for the problem with the substrate to Aster Elements. They took the substrate as is, and there are ways that you hang ACM panels when there are deviations and imperfections in the substrate. That's why Ohio Fabricators was hired to do the job. They proclaimed themselves and submitted a proposal to do this work on the basis that they were the best qualified subcontractor to do the work for Aster Elements. That's the basis for our counterclaim for negligent misrepresentation in the pre-contract discussions. That Ohio Fabricators had indicated that they had the ability, they had the manpower, they had the expertise to be able to hang. That's why they were engaged, was because of that proclaimed expertise in hanging these ACM panels and being able to deal with the issues that were confronted on the job site. If it was 1 or 2 panels, I could understand that being a problem. I'm guessing that Mr. Torrance in his presentation will give you a better idea of just how expansive the problems were here, because travelers had to go in and basically remove all the ACM panels and reinstall them to the tune of, I think it's around $2 million at this point in time that they've had to incur to repair the work. Now, let me make one comment about the factual recitation of Mr. Stabnicki, because I don't want to get bogged down into the facts, because that's exactly where he wants me to go, because then it's going to seem as though there's an issue of fact. There are no issues of fact, but there is one I will take extreme exception to, and that's his initial comment that Ohio Fabricators basically worked for free on this project. First of all, they were paid over $1 million to do the work. They actually got paid over $1 million. So this concept that they work for free is just flat out untrue. And the claim that they are entitled to $983,000, they are owed, if anything, $155,000. And they've added items on top of that to get up to the $983,000, but they are not owed anything close to that. Let me talk about the if paid clause. It is clear from the judge's opinion in this case that she looked at the language of the agreement, but more importantly to the judge, and it's throughout her opinion, she pointed out to Mr. Sickles' deposition testimony. And as much as Mr. Stabnicki wants to try to recharacterize what that testimony was by saying the questions weren't real clear, maybe they were taken out of context, I invite the court to read from page 1 to page 282, or however long Mr. Sickles' deposition testimony is, every single question and answer that he gave. And it was clear to the trial court judge, it is clear to the appellees, I think it is clear, it would be clear to this court, that what he indicated was he understood, regardless of whether the contract in the general conditions said owner, or whether it said pioneer, or had some other name, he understood that he was entering into a paid, if paid, contract. And that's what his testimony was. Now, at the point in time when that issue came up in the summary judgment, obviously Mr. Sickle and Mr. Stadnicki didn't like that testimony, so they tried to submit an affidavit from Mr. Sickle indicating, well, I didn't really understand it. It's also very clear that when you oppose summary judgment, you cannot use an affidavit to contradict what you testified to in your deposition without explanation as to why that testimony should be taken differently. And that's what they're trying to do here. They're trying to create an issue of fact after the summary judgment was filed, and it was clear that his testimony was devastating to them on the paid clause. And they tried to create an issue of fact, and the Ohio Supreme Court has clearly said a non-moving party is prohibited from doing that. I would submit that the idea that if paid clauses are disfavored in Ohio has been dispelled by the Ohio Supreme Court in the Transtar opinion. They are enforceable. It is designed to shift risk, and Mr. Sickle was an experienced contractor, and the idea that somehow he was confused or didn't quite understand what the terms were for his engagement is just flat out untrue. Let's talk about the joint check agreement for a moment. What's interesting about the joint check agreement is, as much as it was made reference to in the summary judgment briefing as far as the factual recitation of what took place here, the joint check agreement didn't become an issue until after the court had granted summary judgment. And at that point in time, Mr. Stadnicki was grasping at straws to figure out some way in which he could try to persuade the trial court judge to reverse her opinion. And the focus on the joint check agreement didn't occur until he filed in December of 2017 his motion for reconsideration and or to vacate the summary judgment opinion. So it wasn't even an issue at the point in time when he was briefing the summary judgment to think that, hey, maybe that joint check agreement somehow altered the paid clause. In fact, if you look at the language of the paid clause, it has nothing to do with the joint check agreement. It has nothing to do with the if paid clause. It clearly indicates that it doesn't change any other terms of the contract other than the mechanism by which the checks were going to be made.
7 minutes and 30 seconds.
Okay, thank you. As to I'll finish on this one note. As to this prevention doctrine, there is no indication that the failure of Aster to be paid and in turn to pay Ohio Fabricators has anything to do with anything that Aster itself did. It was all based upon the fact that the project, the installation of the ACM panels, was done improperly by Ohio Fab, and that's the only reason why they have not been paid at this point in time, and why Aster hasn't been paid at this point in time, is because of the fact, the failures of Ohio Fabricators. Nothing to do with Aster elements. I could stand up here all day and dispute the recitation of facts that Mr. Stadnicki gave you in terms of problems that he attributes to Aster elements, but I'm not going to go down that path because that's just going to raise the prospect that there's a genuine issue of fact. There are no genuine issues of fact in this case. It's an issue of law, and the trial court got it right, and we would ask the court to affirm the trial court's summary judgment. Thank you.
The counsel, you have 6 minutes and 30 seconds.
Thank you very much, Your Honor. If it pleases the court, my name is Alan Torrance. I'm here on behalf of the appellee Travelers Casualty and Surety Company. Travelers' role on this project is that of a bonding company / surety, because under their bonding arrangement with Aster Elements, not to get too technical on the terms, but Aster Elements is considered the principal, which is short for principal obligor on the bond. The surety has secondary liability on the bond as well as the Aster Elements contract. It's technically with Pioneer, with whom Pioneer was here, Aster Elements here, Ohio Fabricators here. Ohio Fabricators has the right, under the payment bond, to make a claim against the payment bond. I'll get to it in a minute. That doesn't mean there's absolute liability under the payment bond. If Aster Elements is not liable under the subcontract to Ohio Fabricators, then Travelers, as Aster Elements bonding company, cannot be liable to Ohio Fabricators. That is surety 101, it's surety common law. The language of the bond doesn't change that one iota. So if Aster Elements is not liable, neither is Travelers. I'm going to do my best not to cover what Mr. Fitzgerald has covered, but one of the items that I do want to raise is that while Mr. Stavnicki in his opening comments may think this is unfair, may think that his client didn't understand it, if you do look at his client's deposition, he understood it completely. And if you look at, he's an experienced contractor, as Mr. Fitzgerald said. He said he read the subcontract, he understood the subcontract. There's the initial contract, which is about 7 pages, has some pay of paid language in it. It clearly defines, as the trial court understood, and Mr. Sickle on behalf of Ohio Fabricators understood, that the pay of paid, the owner under that contract was Pioneer. It was not Cincinnati Children's Hospital or anyone else. And he completely understood. By the way, Mr. Sickle was designated as the corporate designee on every topic in the notice of deposition. So he testified about everything. And he testified that he understood what a pay if paid clause does, and he recognized that he was assuming the risk of non-payment, which we know from the case laws what happens, that he was assuming the risk of non-payment from Pioneer to Aster. And he entered that subcontract knowingly and fully informed as to what he was agreeing to. Now, the contract balance on this project is $155,000. All that between $155,000 and the $930,000 that they would like to recover are what are known in the construction business as impact claims, unpaid change orders that were not approved, labor inefficiencies, unjust enrichment, all those which construction lawyers like to call essentially soft tissue injuries, because you can't point to anything in the subcontract that says I'm entitled to this. So what you say is, this is what it cost me, you got the benefit of my extra effort. Well, when you have a written subcontract in place that defines the roles and the rights and obligations of the parties, those soft tissue claims are not cognizable. And the trial court fully understood that. So unjust enrichment and all the other claims that were asserted don't apply to Aster Elements, and they certainly don't apply to Travelers either. Now, if I have the time, I'm going to try to make a few points here.
2 minutes and 20 seconds.
I'm sorry, Your Honor?
2 minutes and 20 seconds.
Okay, so let me get out through some of my major points. The first point is that counsel for Ohio Fab is torturing the facts. If you read the deposition testimony, if you look at the contracts, if you look at the joint check agreement, what was quoted as being controlling versus what was actually in that joint check agreement, and I can tell you because I drafted the joint check agreement, it preserves all the rights in the subcontract. It was only to get an advance payment back in 2014 to keep the job moving so that there wouldn't be a major default. And it only covered 2 payments. In addition to a tortured reading of the facts, counsel is asserting a tortured reading of the law. Pay if paid clauses are not disfavored by the Ohio courts. In fact, they're enforced, and we know that. There's an argument in the brief that somehow Travelers, or maybe even Aster, admitted liability based on our alternative argument that plaintiff's claim is capped at $155,000. I think what it says in our brief, in our response to his motion for summary judgment, in support of our motion for summary judgment, is, quote, plaintiff claims, if at all cognizable, are limited to the compromise amount of $155,000. There's an argument in the brief, not raised today, that essentially the surety's liability based on the terms of the bond is absolute. I would submit to you that that would put surety law on its ear. That the bond itself is, that the bonding company has no contractor defenses. Those are available under the common law. one argument that was not asserted today, I don't think, but was asserted in the brief, is that Ohio Fab argues that his client did not have the general conditions. And I can tell you that is flatly, and I mean flatly, contradicted by his own testimony. At trial docket 72, page 48, lines 9 through 23, not only did Mr. Sickle admit to having them, he testified that he actually asked for them and received them and reviewed them before he entered into the subcontract. He knew what he was doing.
With that, you're up. Your time is up.
Okay, all right, thank you.
Thank you, Attorney James.
How many seconds, Your Honors?
1 minute and 31 seconds.
All right, I'm gonna go fast, which is always easy for me.
All right.
Never claimed that he never had the general conditions. In fact, if you look at the trial court docket, the general conditions are attached to our contract, attached to the motion for summary judgment. Sometimes silence speaks volumes. You'll notice that the defendants never touched with a 10-foot pole owner, Pioneer. Can't, because it doesn't make any sense. They talked about, oh, Ohio Fab created all these problems on the job and the panel came loose. The panel came loose. It's correct. Whose plans were used to install the panels? Whose plans required how they were installed and how many fasteners were using? Aster's, and Aster's not an engineer, as we know. Joint check agreement, they said that the joint check agreement was never referenced until post-summary judgment, until after we got into the briefing on summary judgment. True, because no one thinks that the court is going to redefine the term owner to be a different defined party in the same agreement. It's like calling Joe Sally. Yeah, so when we realized that the trial court had lost its way, we presented it, because otherwise it's simply payment. Bond language, real quickly on the bond language. I think we're missing the point on the bond issue. We're not saying that the bond is liable under every circumstance known to man. What we're saying is that the contract, that the cases cited by the bonding company deal with very specific sets of facts. And in none of the cases that they cite do they have the language that they have in this bond, which says, notwithstanding any omission in the work or change in the contract, the bond remains liable.
If you're going on to another point, you're out of time.
I'm done, Your Honors.
Okay,
I
very
would
good.
thank you for your time. We would ask for a reversal and that we write the decision from the trial court. Thank you very much.
Thank you, each of counsel, for your presentations and arguments today. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail you each a copy of the decision on the day it's released. Also, the opinions are posted on the Supreme Court of Ohio's website, so you can check there as well.